and I appear pro se as the appellant in this instant case. This is my first time before this honorable court as a pro se litigant, and I respectfully request for your consideration as I present my arguments. I'll reserve any remaining time for rebuttal.
All right, and please understand if you use up all your time, you'll have no rebuttal. All right.
Yes, Your Honor.
Thank you.
Mr. Bane, would you care to move that microphone just a little closer to your, there you go. Thank you. There you go.
Okay, this case commenced on December 15, 2008, when Martha Bane filed her first action to cancel a 2020 warranty deed for real property in Cott County, Tennessee, against John and Ann Bane. In 2008, the trial court entered a default judgment setting aside the warranty deed and issuing a clerk and master's deed to Mrs. Bane. She transferred the property to the Martha Harrison Bane Irrevocable Trust, and then in 2010, it was transferred to the Martha Bane Trust, which held sole title. In 2014, Mrs. Bane filed a second action to cancel a deed of trust held by J. Allen Kingery, naming Kingery and John and Ann Bane. On November the 19th, 2014, Kingery and the defendants moved to intervene and set aside the default judgment, citing Kingery's indispensability. On March 30th, 2015, the trial court granted the defendant's motion, finding Kingery indispensable and consolidating the cases. In September 2015, the court deemed the Martha Bane Trust indispensable and ordered a title search to join all parties with an interest, but the irrevocable trust was never added as a party. A 2018 bench trial led to the February 12, 2018 final order dismissing Mrs. Bane's claims and nullifying my deed and the trust deed without litigation or proper notice. After Mrs. Bane's death in 2018, I was substituted as executor. On June 28, 2019, this court vacated the March 2015 and February 2018 orders stating, we remand this matter to the trial court for entry of sufficient findings of facts and conclusions of law regarding the legal basis for the trial court's decision and to set aside the default judgment, or, in the alternative, reconsideration of that order. In June 2020, the trial court reaffirmed the March 2015 order, finding the first action a declaratory action. My 2023 motions to intervene and to correct the record were denied. Specifically, my motion to intervene was denied as untimely, prompting this appeal. This is a declaratory judgment action, and the trial court's 2020 action confirmed. Tennessee Code annotated 29-14-107 Part A mandates joinder of all parties with an interest, a jurisdictional requirement per Bane v. Bane. Hood v. Jenkins holds that judgments without jurisdiction are void. Subject matter jurisdiction defines the court's power. Without it, orders are nullities. The Martha Bane Trust, sole title holder since 2010, and the Irrevocable Trust, with a prior interest, were indispensable parties. The March 2015 order vacating the default judgment altered the chain of title, directly affecting their interest as legal owners. Yet neither trust was joined or properly notified, nor were their deeds litigated. The February 2018 memorandum of opinion contained no mention of these deeds being set aside, denying due process. The September 2015 order recognizing the Martha Bane Trust's indispensability came 6 months too late to cure this flaw. Turner v. Turner permits void judgments challenges at any time. The defect voids the March 2015 order, tainting the February 2018 final order, which created a cloud on the title. The 2020 order affirming the declaratory nature underscores the need for all indispensable parties from the outset. The September 2015 ruling already deemed the Martha Bane Trust indispensable, meaning the March 2015 order was issued without the property's sole owner, a fatal error under Hood v. Jenkins. This failure to join the trust violated fair judicial process, undermining the integrity of the court's actions. The appellee asserts Mrs. Bane represented the trust, eliminating joiner requirements. However, the trust's distinct entities with fiduciary duties to beneficiaries could not be fully represented by Mrs. Bane, whose personal claim to the property conflicted with their interest. She received no proper notice that the trust deeds were at risk, making representation impossible. Overby v. Overby voids judgments without notice. Tennessee law mandates direct joiner, not proxy representation by someone uninformed of the stakes. The appellee's new claim that the Martha Bane Trust wasn't an indispensable party is waived, as it wasn't raised below, and contradicts the September 2015 finding. This absence creates a fundamental infirmity, voiding the judgment. The March 2015 order jurisdictional flaw is stark. It vacated the default judgment, citing Kingery's indispensability, yet ignored the Martha Bane Trust, the sole owner with a far greater stake. This contradiction is a jurisdictional defect. The failure to litigate the trust deed compounds this error, rendering the order void and undermining the February 2018 final order, which nullified my deed without due process. I have standing to challenge the void order. City of Chattanooga versus Davis grants standing for parties with a distinct injury, causal connection, and redressability. The February 2018 final order nullified my deed, inflicting concrete harm, loss of my property rights, redeemable by vacatur. The appellee's reliance on the Foster Business Park is misrepresented, as I seek relief for my own injury, not the trust. Turner v. Turner confirms void judgments are attackable anytime by affected parties. This order's impact on my title gives me clear standing to seek justice. The trial court's denial of the 2023 intervention motion was an abuse of discretion. Tennessee Rule of Civil Procedure 2401 permits intervention for affected parties with an interest. I received no proper notice my deed was at risk, and Ramsey v. Custer voids judgments without notice. The court's untimeliness rationale lacks findings, violating Tennessee Rule of Civil Procedure 5201 per Regions Bank versus Bloomberg Trust. The court allowed Kingery's intervention in 2014, 5 years after the default judgment, but denied mine despite my stronger interest as a deed holder. This arbitrary inconsistency silenced me in a case that took my property, denying my right to be heard. The 2023 sanctions for untimely intervention were an abuse of discretion. Tennessee Rule of Civil Procedure 1103 requires specific violation findings per Lindsay v. Lambert. The court's vague order, merely noting delay, fails that standard. My challenge was grounded in Tennessee Rule of Civil Procedure 60.02, Part 3, permitting void judgment relief anytime. The 2020 order stressed the importance of proper notice, yet I was sanctioned for raising similar issues. A chilling effect for a pro se litigant like me, navigating complex law to protect my property from an unjust order. The February 2018 final order nullified unlitigated deeds, violating Brown v. Brown's rule against judgments beyond pleadings. The court's failure to correct this ignored Smith v. UHS of Lakeside's mandate for independent judgment. The 2019 remand demanded clarity, but the 2020 order failed to address the trust's absence. The cloud on the title harms both parties, as the appellee faces the same uncertainty, unable to fully use the property. Thank you, Your Honor.
Thank you, Mr. Bane, and how much time does he have left? 6.5. Okay, you've got 6 minutes left. Thank you. Actually, you can only reserve 5 for a rebuttal, so 5 minutes. Okay, thank you. Good afternoon.
May it please the court, my name is Rebecca Harbin, and Mr. Gross and myself have been representing John Bane for quite some time now. This case has a long history. It was filed in 2008, and this is the third appeal where it's been before this court. It was before the court in 2018, 2020, and now Mr. Bane has filed his third appeal in 2024. The judgment that Roy Bane appeals in this appeal is the trial court's denial of Roy Bane's motion to intervene under Rule 24 because it was not timely filed, denial of Roy Bane's Rule 60 motion for relief from judgment, imposition of Rule 11 sanctions against Roy Bane when he delayed filing any motion to intervene as a necessary party for 8 years after he became aware of this matter, and approximately 5 years after he became the plaintiff in this matter. And finally, denial of a Rule 59.04 motion to alter or amend that prior order denying Mr. Bane's request to intervene. As I said before, this is a case that was filed in 2008 by Martha Bane, who is the mother of both my client, John Bane, and Mr. Roy Bane. She sued John Bane in 2008 for undue influence concerning a 2003 warranty deed. Although Martha Bane did obtain a default judgment against my client, John Bane, in 2009, the trial court set aside that default judgment when Martha Bane again sued John Bane in 2014. The trial court found that there was a necessary party that had not been named to the 2008 lawsuit, and so it set aside that judgment. Now, in September of 2015, we have the first evidence of Roy Bane attempting to insert himself into this lawsuit. And he mentioned multiple times during his argument that there was some finding that the trust was a necessary party, and that's simply incorrect. The record would reflect at Volume 1, page 36, that the trial court made the following finding with respect to a motion to intervene that Roy Bane filed in 2015. The motion of Roy Bane, trustee of the Martha Bane Trust, is not well taken as filed, and the same is overruled. Roy Bane may be entitled to intervene in this action in his individual capacity upon the filing of a proper motion demonstrating his interest in the property at issue in this cause, and that's in September of 2015. And so I'm not sure what he's referring to when he says that there was a finding that the trust or the trustee was a necessary party, because that never happened. In any event, this matter was tried before the trial court on the merits in February of 2018, more than three years after Roy Bane was invited to file his motion to intervene individually. He didn't do so. Following the trial on the merits, the trial court ruled in favor of our client, John Bane, and Roy Bane, well, at that time, Martha Bane was alive, so Martha Bane appealed. During the pendency of the first appeal, Martha Bane passed away, and this was in 2018. Following Martha Bane's death, this court entered an order on October 30th, 2018, which is attached as Appendix 1 to our brief, and we requested the court take judicial notice of its prior orders in this case, substituting Roy Bane as the plaintiff in the place of Martha Bane as the executor of her estate. So beginning in October of 2018 forward through today, Roy Bane has been prosecuting his claims against my client as the plaintiff. The first appeal was remanded for sufficient findings of fact and conclusions of law with respect to the trial court's decision to set aside the default in 2015. And with respect to that directive, the trial court found that Martha Bane filed a motion for default judgment on February 9, 2009, and the court unfortunately granted the default by order dated March 23, 2009. The order presented by the plaintiff recited, among other things, that copies of the summonses and complaint were mailed to defendants by certified mail, return receipt requested, and received by John and Ann Bane. These recitations were simply incorrect, and again, unfortunately, this court did not catch the errors. If it had, the default would never have been granted. And so upon these bases, the court reaffirmed its decision to set aside the original default judgment in 2009. Following the entry of that order, and that's Volume 2, page 175 through 76, Roy Bane appealed again. And this court, in 2022, issued an opinion where it found in favor of our client, John Bane. And again, Roy Bane was the appellant in 2022 when this court entered its order. The court found that, relevantly, nothing in the record suggests that the 2003 deed to John and Ann Bane was born of undue influence. On the contrary, the record clearly establishes that suspicious circumstances began to arise after Roy Bane became involved in his mother's affairs in approximately 2006 and 2007. Following this court's opinion, Roy Bane, now this time claiming to be individually asserting a claim in this matter, filed a motion to intervene. He argued that he was a necessary and indispensable party now, even though he was already the plaintiff in his capacity as the executor, and that he had a right to file Rule 60.02 motion for relief from the judgment based on his interest in this property. John Bane filed a motion for sanctions following the requisite notice under Rule 11, arguing that Roy Bane had simply waited too long to assert any rights in this matter, and notwithstanding that he was the plaintiff and could have asserted those rights at any time, it was simply not proper under Rule 24 because it wasn't timely. They also requested that the court deny the Rule 60 motion on this basis. John Bane also represented to the court that he felt that Roy Bane simply waited until he exhausted all appellate avenues, including appeal to the Tennessee Supreme Court, to assert any individual claims in this matter. It's simply a bad faith attempt to get a second bite at the apple and assert the same claims in his new capacity for his own benefit, and we argue that that action alone merited sanctions against him. The court agreed and issued a sanction against Roy Bane and required him to pay John Bane's attorney's fees in the amount of $4,800. Roy Bane now appeals.
And is the appeal from that judgment, from the Rule 11 sanction judgment?
He also filed a Rule 59.04 motion following the sanction judgment, arguing that the court lacks subject matter jurisdiction in the absence of necessary and indispensable parties himself. And so it's the appeal of the denial of the Rule 59.04 motion, but at issue, he also challenges the sufficiency of the findings in the Rule 11 order entering sanctions against him. So with respect to the standard of review, this court reviews a trial court's decision as to who is necessary and indispensable for an abuse of discretion. With respect to the denial of a motion to intervene for timeliness, that's also an abuse of discretion. Imposition of Rule 11 sanctions is also an abuse of discretion. And so I'll go through each of Mr. Bane's arguments. First, Mr. Bane doesn't have standing to bring any argument on behalf of either the Martha Bane Trust or the Martha Bane Irrevocable Trust individually. The trustee does, but that's not who's appealed this decision. It's Roy Bane individually. And he does assert in his brief that the indispensable parties here on page 14 of his brief, while the court set aside the default judgment, citing the absence of Alan Kendry as an indispensable party, it made no mention of the other indispensable parties, the Martha Bane Trust and the Martha Harrison Bane Irrevocable Trust, who were equally absent and equally necessary for the court to possess subject matter jurisdiction. Roy Bane does not mention that he is necessary and indispensable, and he cannot bring the claims of other parties, being the trustees of those trusts, before this court. Mr. Bane also misinterprets the distinction between what is a necessary party and what is a proper party. And so Roy Bane argues that these are necessary and indispensable parties. However, this court has previously determined that in Moore versus Tendleton, that while a party may be necessary, a proper party is only a party who will be directly affected by a decree and whose interest is not represented by any other party to the litigation is an indispensable or necessary party. That is one without which no valid decree may be entered settling the rights between the parties that are before the court. And so there's a requirement to be necessary and indispensable that there's no one else representing your interests. Here, Roy Bane was the plaintiff. He was the plaintiff as the executor of the estate of Martha Harrison Bane. He was representing his own interests as the beneficiary of the trusts. And if Martha Bane's goal in the original lawsuit was to set aside the deed so that the deed into Roy Bane could stand, their interests are completely identical. And so he has been adequately represented, such that he may have been a proper party, but he's not a necessary party. And the court had subject matter jurisdiction because it determined that it had all necessary parties in front of it when it entered its final judgment in June of 2020. The trial court also did not abuse its discretion in finding that the motion to intervene was untimely. One of the elements that the court must have considered in ruling on a Rule 24 motion is that the application for intervention must be timely. And the court reviews certain factors in determining the timeliness of a Rule 24 motion to intervene. And those include the point to which the suit is progressed, the purpose for which intervention is sought, the length of the time preceding the application during which the proposed intervener knew or reasonably should have known of his interest in the case, the prejudice to the original parties, and the existence of unusual circumstances mitigating against or in favor of intervention. And generally, intervention after entry of the final judgment is not timely, and that's what we have here. We have a Rule 24 motion that was filed 8 years after Mr. Bane became aware of his right to file it, 5 years after he became the plaintiff in his capacity as the executor, 3 years after the entry of the final judgment, and about a year after the Supreme Court denied review. This is not a timely motion to intervene, and so the trial court did not abuse its discretion in denying that motion. As to the sanctions, pro se litigants are subject to the same rules substantively and procedurally as attorneys. The sanction requested was payment of the attorney's fees that John Bane has incurred in defending against Roy Bane's motion to intervene that, as I discussed a second ago, was not timely. It was not supported by existing law. Roy Bane made misrepresentations to the trial court that there was some prior finding that the Martha Bane Trust was necessary, and there never has been. And so the trial court did not abuse its discretion in determining that Roy Bane untimely sought to intervene in this matter and imposing the sanction of awarding attorney's fees in favor of John Bane for responding to the motions. Finally, we have requested an award of attorney's fees incurred on appeal because this is a frivolous appeal, and we requested under Tennessee Code Annotated 27-1-122, which provides that when it appears to any reviewing court that the appeal from any court of record was frivolous or taken solely for delay, the court may award just damages against the appellant, which include but do not need to be limited to cost, interest on the judgment, and expenses incurred by the appellee as a result of the appeal. This is a frivolous appeal. This is the third appeal. This is Mr. Bane's attempt to get a third bite at the apple after this court has ruled against him, after the trial court has ruled against him, and after the Supreme Court has ruled against him. We believe that this was a frivolous lawsuit, that it was not a good faith attempt to relitigate the same claims, and we respectfully request our fees on appeal. And if the court has any questions, I can answer them.
Hearing none, thank you.
Thank you.
Mr. Bane, you have 5 minutes.
The first appeal was remanded based upon the lack of findings by the trial court. That's the only reason we had to have the second appeal. On the final order, there was nothing in the memorandum of opinion that stated that my deed should be set aside or the trust deeds were set aside. At no point was the setting aside of the trust deeds or my deed ever litigated or even pled. And that was one of my arguments in my filing. As far as the Martha Bane Trust, the Martha Bane Trust was found to be allowed to intervene as a necessary and indispensable party. That is in the September 15th, 2015 order by the trial court. When it went up on appeal, this court even recognized the same thing that stated that the Martha Bane Trust was allowed to intervene as an indispensable party. This is not a frivolous appeal. This was a jurisdictional issue. I thought it was lack of subject matter jurisdiction because if nothing else, the Martha Bane Trust, which this court found, not this court, but the trial court found, was a necessary and indispensable party and was the sole owner of the property, was not present when the March 2015 order was adjudicated. And so if Mr. Kingery
Was not present or was not a party?
he was not a party, neither one. I'm sorry, Your Honor. So he was not a party. He was not allowed to intervene until September 15th, 2015. And so that was 6 months after the order had been done. My position was that the court didn't have subject matter jurisdiction because the property owner was not party to the case. The Martha Bane Trust was the sole owner of the property at that particular time. Martha Bane was the only party to the case on the plaintiff side when the March 2015 order was adjudicated. And Martha Bane was trying to get the property back, but at no time did the appellee ever litigate or even make a suggestion or ask the court to set aside the Martha Bane Trust deed or the Martha Harrison Bane irrevocable trust deed or my deed. And in fact, if you go back and look at the memorandum of opinion and the findings of facts and conclusions of law, one of the reasons that I asked to intervene was I wanted to correct the record. The final order did not accurately reflect what the findings of the trial court was. At no point in that memorandum of opinion did the trial court state that my deed should be set aside, or that the Martha Bane deed should be set aside, or the Martha Harrison Bane irrevocable trust deed should be set aside. It appeared to me that once you had trial, that the prevailing party, the attorney, when they were drafting the order, there was an, oh, I forgot to do this. And it was actually entered into the final order, but it didn't accurately reflect what the trial court found. So, thank you, Your Honor.
Thank you. Thank you both for your arguments. We'll take this matter under advisement. That concludes the afternoon docket.